on to Renters' Rights Bill, which I'm going to do for you this time. So Renters' Rights Bill, I think everybody's heard of now. It's no surprise, it's been rumbling away since 2019 when it first came up in the Queen's speech. It was the Renters' Reform Bill at that point, then obviously with the new government they picked it up, changed it to the Renters' Rights Bill. It's more or less a carbon copy. They've done a few sort of shifts around, but we are expecting it to come into force within the next 6 months, although we have been saying that, but we are definitely getting closer there. So, a few dates here. The last time it went into government was on the 8th of September when there was when the debate on the Lords amendments began. The House of Commons rejected all of the Lords' proposed changes, I think apart from one, which was to do with agricultural properties, where farmers could actually get their agricultural properties, get possession of them to put farm workers in. I think they've actually accepted that one, but all of the other proposed amendments were rejected. So it's now being sent back to the House of Lords with what they're calling ping pong at the moment. It's going back and forth, so there are some possible next steps of what could happen. One, the Lords may accept the Commons decision, as in how it stands at the moment, where no amendments have been made apart from the one. The Lords may insist on their amendments and return the bill back again to the Commons, or the Lords may propose new alternatives to the amendments that they've made. So we're expecting the next, I think it's going back into the House of Lords on the 14th of October for the final stage. So then, when it goes back in, they should pass it through for royal assent, and the timings at that point will be confirmed after royal assent, and we will then know when it's actually going to come into effect. Has that stopped? Oh, that's better. Yeah, they're thinking it's probably going to be early 2026. Could be January, could be March, we don't know yet, so, but it is fairly imminent. So what's going to happen in the Renters' Rights Bill? Tenancy formats, first of all tenancies will be indefinite periodic. So at the moment we have assured short-term tenancies, most of them are fixed terms of 6 months, 12 months, 2 years or whatever. So all tenancies from the point of when legislation comes into effect, they will all be periodic tenancies. All fixed terms, break clauses and notices to quit will be banned from that point onwards. If a landlord actually proposes it or gives a tenant a fixed term agreement, then a landlord can actually receive a civil penalty fine of up to £7,000. You're going to see this quite often throughout these slides here, because it's not just a case of at the moment where if a landlord doesn't do something, they may not be able, Section 21 may not be valid. It's all about civil penalties and fines. The tenants can give 2 months' notice. So this we're taking as a positive, because at the moment with periodic tenancies, so after the initial fixed term, most periodic tenancies, the tenants can just give 1 month's notice. Well, actually going back to the Housing Act 1988, there's nothing in there which states the tenants must give any notice at all, but most contracts do actually state that the tenants should give 1 month's notice. So this is being extended in the new legislation so that tenants must give 2 months' notice if they want to move out of the property. So that gives us a little bit more leeway in sort of remarketing and getting a new tenant into the property, finding the right tenant and getting everything set up. So you should have sort of fewer void periods here. Landlords must give the government or government-specified terms. Now this is going to be either in the form of a new sort of tenancy agreement where the government will actually provide a statutory agreement, or they will provide statutory terms which must be included within the agreement. So again, they must be, that will be sort of the law, again I think subject to a fine of up to £7,000. Existing tenants must be given notice within 1 month of the Renters' Rights Bill coming into effect. So the existing agreements will remain as they are, so whatever tenancy agreements you've got in place for your existing tenancies, you don't have to serve new agreements, but you will have to serve a statement of terms to the tenant within 1 month. But the existing agreements will remain in place. It's just all those new terms will have to be given to the tenant. Only deposits and not rent will be allowed to be paid before signing a tenancy agreement. So this means at the moment we ask for the first month's rent and the deposit up front, usually before the tenancy agreement is actually signed, but the way that they're stating it now is that only deposits can be paid before the tenancy is signed. You can only ask for the first month's rent once that tenancy is actually signed, which creates a few more problems here, because once the tenancy is signed and executed, then you have to give the keys to the tenant. So you have to make sure you've got a good system in place where got it signed, got it executed, and then you get that rent from the tenant. And agents will be directly liable for penalties if they have undertaken to provide their landlords or provide the tenants with the paperwork. So if you're engaging an agent to find a tenant and set the tenancy up, if they do something wrong, if they collect the money in advance, it will be the agents that are actually liable. So again, we're taking on that liability as agents. Okay, going on to termination, how you can end a tenancy agreement under the new law. This will be under Section 8. There will be no more Section 21. Section 21 is the notice, the 2 months notice. It's called the no-fault eviction, what they've been calling it in the news for the last few years. That will be completely banned. Landlords will not be able to serve notice without giving a valid reason. Landlords will only be able to serve notices under Section 8 of the Housing Act on valid grounds with set notice periods. All those notice periods are changing as well. They're all doubling generally. Defective notices, again, will be an offence subject to a fine of up to £7,000. If the tenant leaves on the notice without going to court, landlords or agents can be fined if they have either negligently or deliberately used grounds which they could not rely on. So this is going back to one of the new grounds, for instance, which they're introducing, whereby if a landlord wants to sell a property, then they can actually serve notice and get possession of the property. But if it turns out that they might be giving that as the reason and then not actually putting the property on the market, then the landlord could be liable for a fine of up to £7,000. So you've got to make sure you've got your proof, your paperwork and everything, you've got your evidence in place. There will be a 12-month protected period for tenants. So even though new tenancies will be periodic from the start, the tenant is still protected for the first 12 months. So if the landlord lets a property and say 3 months later they want to sell the property, they will not be able to serve a notice under Section 8 until after 8 months of the tenancy. We use this 4-8-12 number, so it's a 4-month notice that cannot be served until 8 months and must expire at the end of the 12 months. So it's still a periodic tenancy, but the tenants have got the first 12 months protected. Okay, so possession grounds. At the moment there are 17 grounds of possession, 8 mandatory and 9 discretionary. There are a lot more possession grounds being introduced under this new legislation. I think it's about 31 in total. I'm not going to go all through 31 of them now because we won't have time. I'll just go through a few of the important ones. So, ground one. This is in place at the moment, but they're actually sort of expanding on it a little bit more, whereby if a landlord wants to move back into a property, so they're specifying it could be the landlord, the spouse, the civil partner, landlord's children, siblings, grandparents or grandchildren. If any of those sort of close family members want to occupy the property, you can serve a notice to end the tenancy on that ground. Again, you've got to have your proof, you've got to make sure that that actually does happen. 4 months notice under that ground. It was previously 2 months notice, but you will not be able to market or re-let that property for 12 months after that notice expires. So again, you've got that sort of leeway, really. Well, there's no leeway really on it, so that you've got to make sure that if that's going to happen, if that's your reason, then it must happen, because you don't want the property sitting empty where you've got to pay double council tax or be liable for a £7,000 fine. Ground 1A. This is the new ground whereby if a landlord wishes to sell the property or grant a lease of more than 21 years, they can serve notice under Section 8 to end their tenancy, again after the 12-month period. It must be 4 months notice. And you cannot re-let the property for 12 months after the notice expires. They did try to change that in the amendments to 6 months, but that's been thrown out. So again, if you're going to sell the property, you need to make sure that that decision is final and before you actually serve the notice. A couple more possession grounds. We've got ground 8. That's one of the current grounds if the tenant is in severe rent arrears. At the moment, if the tenant is 2 months in arrears, then you can serve notice under ground 8, and that notice is 2 weeks. Changes here where the tenant has got to, there must be a minimum of 3 months in arrears to be classed as severe rent arrears, and unpaid universal credit cannot be used as arrears, and you've got to give 4 weeks notice. So that again extends it, it doubles it all up there. So you're looking really from when the arrears start, it could be a period of 4 months without any rent before you can actually look at going to court for rent arrears. Ground 10. This is a discretionary ground whereby there are some arrears of rent. This one's a little bit wishy-washy, we don't know all the extent of it. So I can't really tell you more about that at the moment, but that is in one of the new sort of proposed grounds. Ground 11, where there is a persistent late payment. When they first introduced this, they gave an example of if the tenant gets, say, to almost 3 months in arrears, and then court proceedings, or they get to 3 months and then court proceedings start, but then the tenant, they end up paying the rent, so it's not quite 3 months, and then they do it again a few months later, and then they do it again a few months later. That's a ground that you can actually try and get possession for. Again, it's discretionary, so it would be up to the court to make that decision, and it would be, you'd need to be able to provide that evidence in order for the judge to be in your favour. Ground 12, breach of contract. That's one of the current grounds. It's anything other than rent arrears. But again, you need to have sufficient evidence that it is good enough to actually call it breach of contract. If the tenant isn't maintaining the garden very well, it's unlikely you'll be able to get possession under that ground alone. Ground 12 will be 2 weeks notice. I won't go through any more grounds, but we do have a full list of all the new proposed grounds. Email me if you'd like a copy of that. We can send it to you so you know what's coming. Okay, so moving on to marketing and rent bidding. All adverts or all offers, if there is no advert, must contain a written rental figure, which must be the absolute maximum of rent chargeable. We don't get much rental bidding, we don't deal with much. Generally, when we put a property on for a figure, that's the figure that we will get for it. However, there has been a lot of rental bidding whereby people who want to sort of get a property, they'll pay more in order to sort of get to the top of the list, but that's all being ruled out. So whatever you advertise the property at, you will not be able to accept any more than that. It will be an offence to do so. Guess what the charge will be, offence, the civil penalty will be. Pet rents must be included with marketing. Now, I don't know whether a lot of you have heard about pet rents. Before the 2019 tenant fees ban, you could actually ask for a higher deposit if a tenant had a pet, but the 2019 Act ruled that out, and so since then we've been able to charge higher rents for landlords, for tenants who have got pets, whereby it will generally account for the additional wear and tear on a property. So the going rate is about £20 or £25 per pet per month, which tends to work quite well. We're able to sort of convince a lot more landlords to accept pets if the rent is slightly higher. But if that's going to be the case, then that must be included within the marketing, and the amount must be included as well. We're having a bit of a debate in the office really, because I'm not sure how this is going to work when it comes to if a tenant takes the rent amount to a tribunal. But we'll have to wait and see what happens there when the first tribunal happens. But yeah, they've stated that all pet rents must be included. Tenants can request a rent reduction within 6 months if the rent increase is above the market rate. So this is all about the first tier tribunal. The first tier tribunal is available now, but just not many people know about it. But the government are going to make sure that everyone knows about it. So if the tenant feels that the rent is too high, a rent increase is too high, they can actually take it to the first tier tribunal and they can challenge that. So rents, again, must be justified. You've got to make sure that if you are increasing the rents, you've got that evidence to demonstrate that it is not above market rate, because it won't, whenever they do decide that, it won't be backdated. So the rent stays at that amount until the tribunal decides whether or not it is justified. Still uncertainty as to what happens if an advert is withdrawn and relisted at a higher price. So again, it's just some advice we've been given here. So we're not exactly sure what's going to happen, what would happen here. But again, it's always making sure that you've got that evidence, you've got sufficient evidence. There's always information on Rightmove, on the ONS statistics, and things like that to demonstrate exactly what market rents are. Okay, next is the database and redress scheme. So this is the Ombudsman scheme that they're introducing, and the database as well, the landlord database. So all landlords must join the PRS, Private Rented Sector Database, and the redress scheme before advertising a property to let. So every landlord must register, and all of their properties must register too. Adverts must show both the landlord and the property ID numbers. So we know that Rightmove, they're updating their software. They will have to make sure that those landlord registration numbers and property ID numbers are listed within the adverts. Costs and processes remain unclear. Obviously somebody needs to work as the Ombudsman and the redress scheme, so somebody's got to pay for it. There will be charges there, so we don't know what they're going to be yet. We don't think this is going to come into force straight away when the new legislation comes into play, because they still need to set all these schemes up. Penalties will apply. What a surprise. Still unclear exactly what information will be visible. I know we get asked this question quite a lot. Well, surely, there's data protection, all landlords and all their information and all their properties, surely they're not going to be displayed on this database. We don't know yet. I would have thought, because there's obviously data protection laws, there's going to be some protection there. for information, but again, we don't have all the information yet. Delays in implementation are likely because they haven't set this up yet. Pets. We will still be allowed to advertise a property with a saying no pets. That's the good news. However, once the tenants are in the property, they can then ask if they can have a pet, and the landlord cannot unreasonably refuse the pet. So we're probably going to get a few tenants who might say, no, I haven't got a pet, I'm not intending to have a pet. They move in day 2 and say, oh, I need to rescue this pet, can I have a pet? So we're not, that's what's going to happen, isn't it? We can't help that from happening. But you could still basically say you can advertise a property as no pets. Concerns that tenants now have an incentive to lie, as I've just said. You will need to prove there are reasonable grounds to refuse a pet. So for instance, if it's a leasehold property and the head lease states that no pets, or it might say no dogs or no cats or whatever, then if you've got that information, if it's a leasehold property and that's what it states, then you can state, you can actually give that reason to refuse a pet. Also, when it comes to shared accommodation, and somebody's got an allergy, so you can try and think of different examples of refusing a pet, but again, you've got to make it justifiable, because if it gets challenged, then you'd end up losing. Both proposed changes, so things like, well, I think what the government was saying is that can we go back on the 2019 Act and get higher deposits? That was one of the proposed changes. That's being thrown out. And also a mandatory pet insurance. I think we've talked about that before. Again, that's been rejected as well. So I think there are insurance companies that will offer pet damage insurance for rental properties. So landlords will be able to take out that insurance. But at the moment, what they're stating is that there will be no mandatory requirements for tenants to have any insurance. And moving on to discrimination. Discrimination laws already apply to property rental decisions, but additional categories have been added. So refusing tenants because they have children or they are on benefits will be an offence. But there may be lawful grounds for refusal in some cases, for instance, overcrowding in a property. So if somebody is applying to rent a one-bedroom flat, for instance, and they've got 3 children, then you could actually refuse for that reason. But again, you've just got to make sure you're absolutely covered when it comes to this. So we've had landlords in the past who've stated that don't want to take on tenants on housing benefit, or because their insurance company has stated that they can only rent to professional people and not on benefits. Well, I think you'll find that a lot of these policies will be changing as well, because again, it will come under discrimination. So you won't be able to sort of use that as a refusal. And also, again, always best to document your reason for refusal, to show that the decision wasn't made unfairly. Always make sure you've got your evidence there. Rental payments. Rent periods must be monthly or less. You will not be able to ask for 3 months rent in advance, 6 months rent in advance. This does create a few problems with us, because sometimes we get, say, somebody who's coming back from overseas, they haven't had any credit in the UK for 5 years, coming back to look after their family or move close to their family, but they've got no credit, and so the only way around this sometimes is if they've either got a guarantor or they can pay 6 months rent in advance. We're not going to be able to do that any longer. You can only ask for rent to be paid monthly. only 1 month's rent in advance allowed unless this was sent pre-renter's rights bill. So if you have a tenancy at the moment where the tenant has paid, say, 12 months rent in advance, you won't have to sort of return the advance rent.